How can I negotiate a non-compete agreement?
Well, first of all, the only time you're going to have any leverage in negotiating a restrictive covenant, which is a non-compete agreement, a non-solicitation, or other type of confidentiality agreement, is before you go to work for a company or some other employer who is demanding or requesting that you sign these kind of agreements. It's the only time you have any leverage. They've decided to make you an offer of employment because they think you're going to make a good employee, or you have some relevant business background or business experience within their industry that makes you a good candidate or good fit with their company. That's the time you should negotiate, not after you've signed it and you're deciding to leave or you want to leave. Companies will never recede, typically will not recede from what they've already got you to agree to in writing. However, when you're negotiating up front with these kind of agreements, the first thing you want to do is make sure that if you leave the company you're going to sign the agreement with, that you can go back to doing what you were doing before. So for example, if you had 100 customers that you were servicing before you came to work for this employer, and you want to make sure that if for some reason it doesn't work out with this new company, that you can continue soliciting these previous customers you had, these 100 employees, you want to write in a clause or an exception that allows you to solicit anyone that you had a prior business relationship with prior to coming to work for this company. So that's one way of doing it. Another way of doing it is to negotiate. What counties am I going to limit myself in the future from working in if I need to earn a living and support my family? So if you know that you're going to be working in the Tri-County area, you then exclude the other portions of Florida so that if you had to move, you could move and still keep working, even if it was just a few counties away. Also the time. What is reasonable? Employers typically ask for 2 years, but you can negotiate down to 1 year if you've got the leverage. 1 year is what I would call the minimum necessary to protect an employer in most cases involving customer lists and vital customer information that's provided to prospective employees. So those are some of the things that can be negotiated. There are other items. We always recommend you visit with an attorney who's skilled in non-compete drafting and understands all of the issues related to non-competes and can give you good advice on where to draw the line, where to negotiate, and when to walk away.